Wagner raised in her contribution that she wants to talk about conservation. That's absolutely what we on this side of the House wish to talk about, which is why we've been forced to discuss mining, because of course the most controversial issue that the Department of Conservation and this country is currently facing on this subject area is the fact that the national government would like to wishes to open up our national parks and other areas of strategic sacred importance to this country for mining. Now, that side of the House may shake their head at me and claim that I am acting as a scaremonger, but let me take them through the rational reasons why you would not need to touch Schedule 4 unless you wish to mine it. There is absolutely no other alternative reason why you would remove land from Schedule 4. I think probably it's useful before we begin to look at the true role of the Department of Conservation, which is helpfully raised in the financial review, and it states there that the DOC manages and oversees the conservation of New Zealand's natural and heritage assets for the benefit and enjoyment of all New Zealand, and the department directly manages public protected lands. Now, we've already spoken about the fact that around roughly 30% of New Zealand's land is locked into the DOC estate, but there are two categories of DOC land, and I think it's important that we draw out the distinctions between the two. When we talk about the Schedule 4, we are not talking about everything. We are talking about those areas which the national government, in the first instinct, decided was important enough that we would give it a special place in our legislation after much discussion and debate. And that is the schedule which has now been questioned by that very same government. And we see in the financial review that some members rightfully put to the department whether or not they felt that their role was being compromised by the fact that they were involved in this review in the first place. And I understand the Director General said the department was advising on the conservation values of the areas under review, and that he did not regard its involvement as contrary to the objectives of the Act. Well, I question whether or not he was allowed to speak out against the department's role in this particular review, and I think it compromises the role of the Department of Conservation as an advocate on behalf of the conservation estate. But before we go any further, let's look at perhaps why this issue has been muddied, and I personally would blame the national government if there is any lack of clarity, about what's going on in this debate at present. And I do have some previous history in this area. Some years ago, I was a private secretary for energy. I worked for an associate minister of energy who had responsibility for mining in this area. I worked directly on Schedule 4 and variations when mining companies wished to make applications for mining on DOC land. I understand the distinction between the two, and the fact that the national government, if they wish to remove land from Schedule 4, it is a very different thing than whether or not you're granted a variation to mine on the DOC estate. They are two different things. Schedule 4, probably the best reasons we can find as to why it was created in the first place are actually, if we go back to the Hansard debate, the third reading by Nick Smith himself, who was the minister at the time who ushered in this important schedule. And if we go back to some of the rationale he provided at that time, he said this bill at long last puts some pegs in the sand in some very significant areas of New Zealand and says to the mining industries of New Zealand, these are no-go areas. These are no-go areas. And the irony of pegs in the sand, given half of Coromandel is back up in question as well. This legislation, and I quote, says to the mining industries that those areas set aside as national parks are not appropriate areas for mining. 10 years on, I'd like to ask the Minister if perhaps at some point he'd like to share with us what's changed. Does he think that those national parks are any less significant to New Zealand now than he did then? Because as far as I'm concerned, everything that's listed on that schedule has remained the same in terms of its conservation value. And he concluded, this is landmark legislation for the conservation movement in New Zealand, and those who were involved, Forest and Bird in particular, were heralded for their role in this important piece of legislation. Now that they speak up against it being reviewed, what are they called? Scaremongers. They're labelled as scaremongers by this government when they were the ones who helped usher it in them in partnership last time. He goes on to say, I welcome the bill's progress and, as Minister of Conservation, look forward to not having to consider mining applications in those areas where nature should be able to rule the roost.